Hello, welcome back to Frenemies Season 3, the series where McGuire Woods' intellectual property and data privacy and security team is helping our marketing and legal departments understand each other, work together, issue spot, and maybe go from being frenemies to friends. I'm Allie Bayardo, a partner here at the firm, and I'll be covering the one where sale doesn't mean what you think, what is a sale, and why does it matter? Before I get started, though, I would like to thank my colleague, Neelam Takar, who won't be joining us today, but she assisted me in developing this presentation. First, I want to walk through what the CCPA is generally. I anticipate if you're watching this episode, you are most likely already familiar with the CCPA, but for those of you who may not be, I'm going to provide a short overview to help orient us and explain why a sale is not what you think and why it matters. California's Consumer Privacy Act was signed into law in June 2018 and represented a sweeping change in California and U.S. privacy law. The stories go that a few people were at a cocktail party talking about big data and what happens behind the scenes, and the question was posed, it really can't be as bad as I think it is, and apparently the answer was it's even worse. And so this group of folks created a public interest initiative, and they started this process. There are a lot of critics of it, and we're going to walk through some of the issues, that are presented by it and how to understand it better. The statute went into effect January 1, 2020, and regulatory enforcement began as of July 1, 2020. So who does the CCPA apply to? It applies to businesses that meet any of the following three criteria. 25 million in gross annual revenue, 50,000 or more residents information is derived from selling, revenue rather is derived from selling California residents' personal information, or 50% or more of the company's annual revenue is derived from processing and selling information about California residents. The CCPA regulates the sale of personal information by businesses that collect this information from consumers. It also exempts service providers working with businesses from its definition of sale, and we're going to walk through who would be considered a service provider and why that's important. The CCPA statutorily defines sale in a way that is extremely broad and imposes very different obligations on a vendor that qualifies as a service provider as opposed to a third party. So you're probably thinking, well, where do I fall? Am I a business? Am I a service provider? So we have here for you the definitions in the statute. A business is an entity that collects consumers' personal information, or on behalf of which such information is collected, and that alone or jointly with others determines the purposes and means of processing the consumer's PI. A service provider, in contrast, you have the definition here, but it is very specific and it has requirements for what the contract between the business and the service provider must cover to make sure that that back-end fear about what's happening with data is protected. And lastly, a third party is simply defined as an entity that's not a business or a service provider. And so there are important considerations in where your vendor might fall. So the requirements to be considered a service provider under the statute has the following requirements. The PI transfer must be necessary to perform a business purpose. The business must have a written contract with the service provider that prohibits the service provider from selling, retaining, using, or disclosing the PI. The business must provide compliant notice to consumers of the fact that it intends to share the PI with service providers. And this is what we've been talking about. The service provider does not further collect, sell, or use the PI of the consumer except as necessary to perform a specified business purpose. We have some examples here of what would be a business versus a service provider. A business is going to encompass most companies, partnerships, commercial enterprises. Doesn't matter if you're incorporated or not. Also, the place of incorporation is not important for purposes of the CCPA. It's focused on California residents' personal information. Now, note that nonprofits, government entities, individuals are all excluded from the definition. Now, a few examples of service providers can be email marketing companies, customer relationship management providers, payment processors, analytics service providers. Essentially, it is some type of vendor that is providing a service to the business with the data. Now, as we promised, we're going to answer the question of what is a sale. So the statute tells us that to sell means we have variations of selling, renting, releasing, disclosing, disseminating, etc. A consumer's PI by the business to another business or a third party for monetary or other valuable consideration. And we've got the statute here. Now, as we think about what that means, there are two other definitions in the statute that are helpful. One of those is personal information. What that means is information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. Now, that's a very interesting definition for a variety of reasons. That reasonable language is very important, and there was a lot of focus on that in the drafting of the statute and how it will be applied. And household is very interesting because it's not just an individual. The household is defined as a family, would be a family or occupants at a residential household. Those households are being treated the same way as an individual when it comes to data identification. So using data to narrow a list of consumer identities to a single household is seen as being the same as being able to identify an individual. So what are the implications of other valuable consideration in the definition of the statute? So the statute itself does not define valuable consideration. California's Attorney General did pass a number of regulations to help businesses and others understand what the statute means, and they advise that the term should simply be given its plain meaning based on how it's used in those business transactions. Now, using the term valuable consideration, not surprisingly, ties back to the base of a contract. You must have consideration for a contract. And we talked earlier about how this statute is aimed at what is happening in the background. And there was concern that business may share information with a vendor and doesn't receive money back for that. But what happens is the vendor provides a service. So say I tell you, business, how folks are, what they're buying based after they come into your store pre-COVID, or what people are buying after they click on a particular link. That's valuable consideration. And then I, vendor, turn around and sell that information. So I'm giving you a service, and in exchange I get the information, and then I turn around and sell it. Well, to be a service provider, that back end has to stop, right? You can't turn around and then sell it and still be considered a service provider. So as I mentioned, this is focusing on different types of data publishers, different ad tech companies and advertisers who target ads, and we'll talk a little bit about the ad tech industry later. But also there's this question of, does personal information encompass cookies? And it's a hot topic. I'm sure you can find a lot of independent articles talking about just that point. And the Attorney General gave some vague information about whether or not it could be cookies, and you have to look at all the facts to determine in that scenario if it would encompass a sale of personal information. But that is something that folks are thinking about, and why you are now seeing, probably when you're on the internet, an increased number of cookie banners saying I accept and getting certain disclosures as part of that process. The statute also instructs us what is not considered a sale, and this goes back to the service provider. And there's some other considerations I'm going to walk through here with you. But we've included here the specific statute where you can go to look at what scenarios would not be considered a sale. So these include where the consumer directs the transfer, and in that scenario, a sale does not occur when a consumer intentionally or directs or uses a business to disclose their personal information. It's considered, the recipient is prohibited from selling the data unless the disclosure is compliant with the CCPA. Another category is using PI to alert third parties of an opt-out. So if I tell the business that I'm opting out, the business needs to turn around and tell anyone else that has my information about that. That's not considered a sale. Disclosing data to a service provider, we've talked about that. And then purchase of a business. So a sale does not occur when a business transfers personal information to a third party as an asset that is part of a transaction in which the third party assumes control of all or part of the business. So we're thinking mergers, acquisitions, etc. And the information must be used or shared consistent with the rights to be informed under the CCPA. So as we promised in the beginning of the episode, we're going to explain to you why does this matter. And there are two main components. One, we want you to be thinking about these important considerations that we've laid out for businesses as they look at their vendors and whether they could be considered a service provider. And two, thinking about litigation risk and to minimize that impact. The first topic, whether or not the provision of personal information to a third party constitutes a sale has important considerations. If your business is working with a vendor that's not qualified as a service provider, there could be important considerations about whether the vendor is permitted to make independent decisions about the use or disclosure of PI, and you often see this going around in the background sale of personal information in the world of ad tech. We can't simply label someone a service provider, and so you have to be looking at your contracts. There are amendments that a lot of folks are doing right now to their contracts to make sure that you have the contractual requirements there to be considered a service provider as opposed to a third party. And if for you, the vendor that you're working with is a third party, then you'll need to think carefully about how and if the CCPA applies in that scenario, and if it's a sale. Ad tech is a big hot topic with the CCPA and these important implications. So ad tech is advertising technology, which refers to using technology to facilitate the buying and selling of digital advertisements. So for example, I go and I search for tickets to a show, and then it pops up on my phone a few minutes later, 30 seconds later. The ad tech ecosystem has two major entities. It has the advertiser, which is the demand side, and then the publisher, which is the supply side. And advertisers, of course, want to get the most they can out of their ad campaigns and reaching their target audience. And publishers cater to this by displaying ads on their publication, maximizing bids, gathering visitor insights. So there are a lot of considerations in the ad tech community as to whether the provision of certain information constitutes a sale, like we talked about earlier, the question of cookies, tracking people. There's a lot of different considerations there. So we have here some specific examples and whether or not it would constitute a sale. As any good lawyer will always tell you, it will obviously depend on the scenarios and specific facts. But we lay out here, a scenario of behavioral advertising. So there, the ad tech provider is collecting data to create inferences to target ads on behalf of a client. This would likely be considered a sale because the ad network is the business using the data to support the publisher and is receiving valuable consideration in exchange. Another scenario is retargeting. There, the ad tech provider tracks what an entity does with a product and retargets an ad for the client's service when seen somewhere else. This likely not a sale, so long as the ad tech provider could be considered a service provider under the terms of the contract and access the data. And here, the ad tech provider would likely be considered a service provider because they're using the client's data to provide the service to the client. Another scenario is direct ad sales and buys. Rather than selling inventory to the ad network, the advertiser directly sells the ad space. So that likely would be a sale so long as the ad provider can be considered a service provider under the terms of the contract. And finally, in our presentation, we talk about minimizing litigation risk. This is obviously a huge part of the CCPA and businesses' concerns. And in part of negotiating the statute in the California legislature, this is a hot topic, of course. And so we have, as I mentioned in the beginning, regulatory enforcement through the California Attorney General's office. They've made clear that they really don't have the means to be aggressively pursuing, and they anticipate 2 to 3 enforcement actions. So that leaves the California plaintiffs bar, right? So the statute itself, on its face, limits private causes of actions predicated on the CCPA. So it provides very specific scenarios when a lawsuit can be brought, and they're related to data breaches, and you have to have the opportunity to cure. So the provision in the statute allows consumers to sue businesses that fail to maintain reasonable security procedures and practices to protect non-encrypted or non-redacted personal information. That's also something you can learn a lot about in terms of how can you satisfy that non-encrypted of a consumer, and further fail to cure the breach within 30 days. A violation of this statute allows recovery of statutory damages of $100 to $750 per consumer per incident, or actual damages, whichever is greater, and also injunctive relief. And to determine the appropriate amount of statutory damages, the court is going to look at the circumstances of the case, number of violations, defendant's assets, liabilities, net worth. So that could be problematic for a number of businesses. And interestingly, there's another part of the statute that says specifically that it shall not be interpreted to serve as the basis for a private right of action under any law. Now, for my Californians in the audience and my litigators, you know the bell's going off in your head that is referring to the unfair competition law in California, which is based on unlawful, unfair, fraudulent business practices. And the idea is you can't predicate your California unfair competition law claim on that underlying CCPA violation. Now, that's what the statute says. We've seen a lot of filings so far this year pleading violations of the CCPA that are not limited to data breaches. And it's going to be very interesting to see what the courts do with all of these cases and either allow a way around how that statute is drafted for the secondary part. But there's also the potential that folks bring claims that don't mention the CCPA but are tied to standards or representations that a business is making on its website to comply with the CCPA, and the allegation is you're not doing what you say you're doing. So those are things to think about as you're working through your CCPA compliance and thinking about what is a sale and why does it matter. Thank you so much for your time today and sharing a little bit with me. I hope you found this presentation informative. Please don't hesitate to reach out to me or any of my fellow McGuire Woods attorneys who you may work with if you want any additional information. If you've missed any of our other seasons or episodes in our Frenemies series, they're available for on-demand viewing on our website. And please tune in for our next episode, which is being presented by my partner, Bethany Lukic, the one with teeth. Did the Attorney General really start CCPA enforcement on July 1? Thanks so much.